Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Honorable Supreme Court of India, two judges bench, Abhay Srinivas Vokha and Pankaj Mittal, held that the accused cannot be given an opportunity to explain before the final report, before the police file the final report. This is in the case of Shiv Sharma versus the State of Madhya Pradesh and others in criminal appeal number 3347 by 2023 dated 30th October 2023. So the heading is, once again repeat, accused cannot be given an opportunity to explain before filing of the final report. You all know the police, after completing the investigation, they will file the final report under section 173 of the crpc. So before filing the final report will be in the shape of maybe the charge sheet or maybe the referred charge sheet. Referred charge sheet means if the police wants to refer the case as undetectable, false, mistake of fact, that mistake of law, or NC, that is non-cognizable. So they will refer it in that matter. That is called a referred charge sheet. Police may file the charge sheet, police may refer the case also. Right, so if you know the facts of the case, you will be understanding the matter issue easily. Here, the case on hand is a case relating to misappropriation of public funds. The appellant, that is Shiv Sharma, while working as assistant society manager of an agriculture society. In Andhra Pradesh, we call it as PACS, Primary Aided Cooperative Society. PACS, to control them. In Ongole, we have got PDCC Bank. So he was working as a marketing secretary, assistant society manager. Right? So an FIR was registered against him that the FIR is having serious allegations of his dwindling with the public money or misappropriation or financial indiscipline or misuse of the public funds for his own use. Actually, the funds are meant for the farmers, but he has misappropriated the same. This is the case. Right? So after the FIR, he has approached the Honorable High Court of Madhya Pradesh for quashment. You all know, quashment is a procedure established under section 482 CRPC to the higher courts for doing complete justice. Suppose if there is the error on the face of record, yes, definitely they will give stay orders. They may ask the they may quash the FIR also. Like that, so many things will happen. So they have filed a petition for quashment of the FIR. But instead of quashing the FIR, since the public funds have been misutilized, misappropriated, lot of investigation has to be done as per the report of the police. So the High Court did not go into the facts of the case, did not go deeply into the facts of the case. Instead of that, what they have done is, of course, luckily, they did not give the quashment orders. The case was not quashed under 482 CRPC. Instead, a temporary relief was given to the accuser, that is appellant, Mr. Shiv Sharma. What is this? The Honorable High Court of Madhya Pradesh directed the police to give a chance or to explain to the accused the material collected against him, whether it is correct or not. So, agreed by this order, by the orders of the High Court of Madhya Pradesh, the people came to the Supreme Court. Now, the Supreme Court said it is a very strange order by the High Court. Strangely, the High Court observed that the investigating officer will give opportunity to the appellant to explain the material collected against him during the investigation. Right? So, before filing the final report under 173 CRPC, please remember, this not after completing the investigation, then only they will come to the final stage. At this stage, there is no necessity for the police to give him an opportunity to give or to explain him the grounds on which the charge sheet is being filed. Of course, you all know, even according to 173 CRPC, a copy of the charge sheet can be given to him, that's all. But here, the intention of the High Court is also correct. Because it is public money, public trust. If the FIR is passed, entire money is gone. FIR is not passed, the rights of the person will be at peril. So therefore, Honorable High Court of Madhya Pradesh, they have thought in their own sense and asked the police to explain or to give a chance to him to explain. Normally, the police will do the same. When a FIR is registered, it is the duty of the police to investigate. Investigation not only on one side, they have to examine the accused also. They have to record his statement also. They have to take his explanation also. If the explanation is not convincing, they may arrest. So please remember, there is no mention in CRPC that the accused should be arrested. The investigating officer may arrest. This is a very, of course, a good provision in my view, but it is a peculiar provision. Normally, you will be under the impression that if A commits the murder of B, he should be arrested. Yes, he should be arrested for maintaining law and order, but not as per law. So it's a different subject. Anyway, here, instead of quashment, they have given the orders that he has to give a fair chance. It is not correct. So therefore, Honorable Supreme Court of India once again restored the matter back to the Madhya Pradesh High Court itself. Please see the record. See whether you can adjourn the case, whether you can quash the case or not. Give a detailed order. So the matter is posted, sent back to Madhya Pradesh High Court, and the matter will be taken up on 8th December 2023. By giving opportunity to the both parties, then the High Court will give the so-called reasoned order. To sum up, I want to say that sometimes the High Court may also error, and it has to be rectified by the Supreme Court. This is what happened in this particular case, because we did not come across any such order that the accused should be given an opportunity to explain to the material collected against him. At the stage of investigation, definitely he will be examined. You might have seen the recent cases. What happened to Chandrababu Naidu? They have gone to the jail. CID people, they have given a list of questions. They have asked him, he replied. Right? Later only they will file the charge sheet. But before filing the charge sheet, they need not ask him his explanation. This is what is envisaged in this particular judgment. So please read the judgment and enrich your legal knowledge. With this, I am concluding. Thank you very much.